Hi everyone, this is Shauna Tarosa, RAYAC's Executive Officer, and this is my desk. In this monthly video cast, I go over questions that are coming across my desk every single day so we can have much smoother real estate transactions here in York and Adams counties. And as viewers of this cast know, I often like to joke that I'm not an attorney and I don't play one on TV. So with us today, we have a real-life attorney, Mr. Peter Ruth, who is our RAYAC solicitor and attorney with Stock and Leader in downtown York. So welcome to my desk, Peter.
Thanks for having me back. I appreciate it.
Oh, you were my favorite guest, if you haven't noticed.
I paid her to say that.
All right. So Peter and I have a really important, really interesting topic to discuss today, and that is working with estate sales. So what do you do as a real estate licensee when the owner of the property becomes deceased? So let's just dive right into this. So, biggest issue, how do I know as a licensee who owns the property? And how do I determine as a licensee who can sign the listing agreement in the event that the property owner has recently become deceased?
That's a great question. So the very first thing you obviously want to do is you check the records, right? You find out with the recorder of deeds whose name is actually on that deed and make sure they actually own 100% of the interest, because sometimes some deeds can transfer fractional interest or things like that. So we find out who the owner is, and then the next step is, as kind of morbid as it sounds, we want to confirm they're actually dead. And the way that we do that is we obtain what's called a death certificate. So that's issued by the state, and that identifies kind of the nature of death, the individual's name, the date of birth, the date that they died. So it has their age as well as everything else in there. And oftentimes we'll also have next of kin. So it may have a surviving spouse or children identified on there. So that's the document you really want to start with, just to confirm the individual who was the owner has now passed away. Mm-hmm. The second document that you're going to want to retrieve depends on whether the person died with a will or without. So when I talk about a will, I'm talking about a last will and testament. A person can die with a will that directs where they want their property to go after they pass. They don't have to do that, though. That's not obviously an obligation. Many people die every day without having that. So if you die with a will, you die testate. If you die without a will, it's deemed you die intestate. So you might hear testacy, intestacy, or things like that. So if a person dies with a will, you're going to take out what are called letters testamentary. So that executor or whomever takes out those letters will now have the power to administer the estate on behalf of what we call the decedent, the dead person. If they didn't have a will, so they don't leave any will behind, then you take out what's called letters of administration. So the two things when you're listing that property you really need to have in terms of documents: the death certificate, and then either the letters testamentary if they had a will before they died, or letters of administration if they didn't. That's going to identify on those letters who has the authority to sign the listing agreement and, more importantly, convey title to the property that was owned by the deceased person.
Okay. All right, so let's talk about this little nuance. So we've had circumstances where there was a child who was the power of attorney for their parent who's still alive at the time. And the parent has assigned the power of attorney for their child to take over because they want to list their house. Their health is declining, those types of things. But in the middle of the transaction, unfortunately, the parent passes away, who was the property owner of the property, and you have a child who's acting as a power of attorney. What happens with that power of attorney? Do I still have an active listing agreement? What should I do?
Great question. So the thing to remember, and the easiest way to remember with the power of attorney, the power of attorney is only valid during the person's life. So that mom or dad who gave their son or daughter that power of attorney to act as an agent for the mom or dad, when mom or dad dies, the power of attorney dies with that person. So that person can no longer exercise any rights or really privileges on behalf of the person who gave that on behalf of mom and dad, just based solely on that power of attorney. So again, power of attorney dies with the principal, the person who gave the power to the agent. Once that happens, the next thing we're going to look for is A, did they have a will? If you have a will, now we're going to again go into finding out who we named as the executor. We'll take out letters testamentary. But the main thing is the POA, their rights and powers stop as of death. That includes the right to basically consummate the sale. Mm-hmm. So if you have a listing, even if you're under agreement, they likely have no power to convey title at that point once the principal dies. So again, unfortunately, you'll have to call up the buyer agent in this case and say, hey, the principal, the owner passed away, we're going to have to open an estate, take out letters, and make sure we have the right person conveying title to you. And the buyer, if they have questions, call the title company, and they'll walk them through that same process. The power of attorney can't convey the property for a deceased principal, only the executor of that estate via letters testamentary or the letters of administration.
Okay, that's an important point.
Yes.
I think everyone needs to recognize. So that a power attorney dies, unfortunately, the day the principal dies.
That's correct.
So,
And the main thing to consider, and we've had situations like this, the power of attorney, the agent who's named for the principal, does not have to be, and oftentimes is not the same person who's named as the executor under the last will and testament. And we had a situation where, the mom was alive, power of attorney is working with the agent to get the property sold. Mom dies, but now the executor named in her last will and testament was the daughter and not the son. Daughter and son didn't see eye to eye in terms of how that plays out, but the main thing is son has no power to say anything anymore as the agent because she passed away. Now it's the executor, the daughter takes over. So.
Oh, well, that leads me into my next complex question. So, what if we're dealing with more than one executor of the estate or of the personal representative? And unfortunately, we're seeing more times than not, they don't necessarily see eye to eye on how that estate processing should proceed. So what's your advice on how to work with executors who do not get along?
Quite honestly, buckle up because it'll be a bumpy ride. All jokes aside, this is really, I think, where agents can exercise some good counseling of their clients. So you've been retained as the listing broker, and the agent is now consulting with the family. The main thing to reiterate, and this is what I try to do, especially, I don't do much in the estate practice, enough to know a little bit about it and be dangerous. But when we're counseling clients in that regard, I know there's going to be differences of opinion. And some might say, well, mom wanted me to have this or dad wanted me to have that. That's all well and good. Few things you need to consider. First of all, you are now an executor of an estate potentially. As such, you have fiduciary duties that are owed to the beneficiaries of that estate, of which you may be one. So if you're administering the estate, you might actually be receiving some of those funds. But odds are you're not the only one. You might have brothers, sisters, nieces, nephews, others who inherit from the estate as well. You have fiduciary obligations to perform and to administer that estate. And if you don't do that, you can be brought before the orphans court and have to answer to a judge as to why you were doing what you were doing, or more importantly, not doing what you were doing. The other thing to consider is a lot of times, like I said, the executor is going to be a beneficiary or co-beneficiary. The more fighting between those executors that occurs, think about it this way, the more an attorney needs to get involved, the more time it's going to take, the more holding on to this asset that is pretty much negatively impacting the estate, right? Because you're paying taxes. If there's a mortgage, you have to pay the mortgage. You're paying for property insurance, potentially now on a vacant property, all of which is costing the estate money. So the earlier those executors can kind of get together and say, hey, I know we're not really on the same page, we don't see eye to eye, but let's work to get this sold. You never have to deal with the other person again at the end of the day. So think about that if that's all that gets you through the day. But honestly, in terms of counseling your clients, it's really understanding you have a fiduciary obligation to perform here. And more importantly, the longer it takes to get to that sale point or to get those assets disposed in the estate process, the more money it's going to cost you at the end of the day. So if you're interested in getting those funds and getting them quickly, work together. So like I said, you can more quickly get out of that situation.
Okay. Good advice. Good advice. So my next big question is about disclosure issues when you're working with an estate sale. So the seller's property disclosure law makes it pretty clear that if you're transferring as fiduciary in the course of the administration of the descendant's estate, you do not need to provide the seller's property disclosure form. But many times the executor does know of material defects on the property because they might have been a child of the parent who owned the property and they know that they got water in their basement every winter.
Right.
So what is their duty? Do they need to disclose that information even though they don't need to provide a seller's property disclosure form? What's your take?
So it's a great question. And this is where we kind of get down what I call the statutory duty. Seller's disclosure law, there's a statute, the law that was passed by our legislature that says you have an obligation to disclose unless you fall into an exception. One of which was the exception you talked about. You're administering an estate, or you could be a trustee who's administering a trust and selling trust property, or any one of those exceptions. So statutorily, like you said, there's an exception. I don't need to disclose as an executor. We also have here in Pennsylvania, especially in the United States, a thing called common law. So common law doesn't necessarily mean it was written in a statute, but what it means is that there's court cases that have developed since the founding of our nation that have said, if you have knowledge as an owner, regardless of your capacity, you must disclose those known material defects, okay? So it's not really a buyer beware. So we always have the situation, and when I taught an ethics class, I always use my example of Buddy. Some people who take my class might know, Buddy is he's a 60-year-old who was living with his 90-year-old mother. Every time there was an issue in the home that his 90-year-old mother owned, Buddy fixed it. Either he called the contractor, he was going up in the attic to repair, any damage, going down in the basement for the water penetration issues. And when mom dies, Buddy now is selling the property. And he sits there and looks at the seller's disclosure, and it very clearly says he's an exempt party. But if he just stops there and doesn't continue to read that, oh, if I have knowledge, I must disclose, he is on the hook for up to 2 years after closing, regardless of the fact that he fit into that statutory exception. So again, it's not always that plain and simple. You might be an executor that had no contact with the property. You might not know anything. But when the person passes away and you come into town to start the administration process, you go to the home and you open it up and you smell that musty smell of water in the basement. You go down in the basement and you see the water pooling there. Guess what? You now have knowledge of a material defect. Right. You now need to disclose, okay? So that's the other thing to consider is there's kind of that two-layer analysis. Statutory exemptions are great, but if you know, disclose. Obviously, keep yourself out of trouble. Easiest way to do that.
Absolutely. Disclose, disclose, disclose. And I think one of the last bit of advice we probably want to share with our members is when you're dealing with an estate sale is there's a lot of scammers out there,
Yes.
Unfortunately.
Yes.
And particularly when someone passes away, they're now trying to pose as the owner of record of the property, even though that person is deceased, and they're becoming quite good at it. And, they're creating all of these electronic documents that back up that they are the owner of record, even though that person is deceased. One of the great things in our area is both York and Adams counties have something called a record notification service. So if anybody tries to record a deed on a property or take out a mortgage on a property that they have to record, the record notification service will send anyone who signs up for that particular listing a notification that this transpired. So we strongly suggest that everybody use the record notification service, but especially if you are dealing with a parent or you're going to be the executor over an estate when someone passes away, if you hadn't signed up for that yet, do it.
Yes, absolutely. Yep.
You don't need to be the owner of record.
Yeah, that's correct. And we've actually had clients in our firm where this has happened, where an estate was being processed, a mother and a son owned property. Both mother and son had passed away, and we're selling it. So the title company for the buyer, in doing their title search, calls us and says, hey, there was a deed not too long ago, a few days, transferring the property into this trust, and it has the mom and the brother's signature, both of whom are deceased, but apparently came back to life, I guess, to sign the deed and have it notarized. So we do an investigation. We find out the deed was fraudulent. It was conducted by this individual who has since been apprehended. Actually was apprehended, escaped apprehension, and then I believe is now apprehended again. But that is going on. These individuals were not enrolled in that record notification system. So again, not saying it would have prevented the issue, but we would have at least known about it much more quickly and could have responded in a much more quicker fashion. So that's the thing to remember is that, you have these available resources out there. There's no reason not to utilize them.
Yep, absolutely. So record notification service, can't say enough good things about it. Tell everybody, sign up for it. Peter, thank you so much for being at my desk today. I really appreciate that.
Always a pleasure.
And if you ever have any questions or issues you'd like us to address in the series, please feel free to reach out to me because my doors and ears are always open to you. Thanks so much and have a wonderful day.